screen and I need to focus on my PowerPoint, so I can't see anything, but I will be able to see chats as they come in. And for those of you who were listening to Laura and I talk earlier, I will be covering any chat questions at the end of each page. That seems to be a good stopping point as we go through this 10-page document. Some of you may have also overheard next year they're going to be expanding this contract to 16 pages. So it's going to be quite a change. The good news is 99 to 98, 88 to 99% of the content will remain the same. So if you know what's on this contract, you're going to know what's on the next contract. So you'll know the information. It's just all going to be in a different place. So that's going to be a little confusing. But I'm sure Laura and I will be scheduling some classes. And of course, your legal counsel for the association, John, he'll be having classes. So you can get John's perspective, my perspective, all that good stuff. So as you can see here from the cover slide, my name is Ed Estes. I'm a full-time professor of real estate at Mount San Antonio College. So I don't list properties, I don't sell properties, I don't represent buyers or sellers. I just teach full-time. But I enjoy talking about forms, I enjoy talking about the contract, because you guys give me great questions, not only that I can bring back and talk about with my students, because they're always looking for real world examples, but it gives me a new or a better perspective of how licensees out there in the industry are using these forms, interpreting these things. So that's always nice. So I will appreciate your questions. So just be sure to use the chat, send them to me, and we'll cover them. The other warning I have, and I'll have this on my last slide as well, even though I am not only a real estate broker, but also an attorney, I'm not giving you legal advice. This is an educational experience. I no longer practice law. Again, I work full-time at Mount SAC, but I can certainly give you referrals to attorneys, and an excellent referral would be your legal counsel, John Gardinelli, very knowledgeable attorney, and nice guy too. All right, so let's go into the contract, and to do that, let's see, we got some preliminary things coming in the chat room. I thought, no, it didn't go.
I got it all handled.
You got it all handled? Okay, great. So let me now move through. Here's page 1, and as we go into the first paragraph of page 1, or first 2 paragraphs of page 1, you'll see at the top, date prepared. Doesn't really matter what date you put up there, because all of your time frames are going to go from the date of signature or the date of acceptance. The only reason we have a place for a date on the top, this would be known as the contract dated September, whatever. Okay, so again, the only reason we have that is to give this contract a name. Note that when you're using the CAR addendum or a counteroffer or anything like that, they always ask, what is this counteroffer to? Is it to the purchase agreement? And they have a place for what the date of it is. So that's why we have a date up there. Then, first line, very important to put in all the names of your buyers. So you may have some additional buyers coming on, perhaps a parent, uncle, grandparent, going to help with the pre-qualification or the down payment or something like that. You want to list all the names of the buyers there on that line. Remember, this contract does not or is not allowed to be assigned. So you cannot add additional buyers or switch out buyers without the seller's permission. Now, the seller's permission is not supposed to be withheld unreasonably, but paragraph 26 of the contract does prohibit assignment. So if you want to allow assignment, what you would do in 1A is say, Bob buyer and or assignee. And then when we get into paragraph 6, other terms, you'll want to write in there, paragraph 26 is deleted. Now, before you start going through your contract to try to find all that stuff, don't worry about it. I will talk about it when we get to that section of the contract and remind you. So just stay with me as we're going through this contract. I won't leave you behind. I won't forget something. And if I do, Laura will reprimand me. Or you could send me a chat and say, Ed, you forgot something. And I'll be happy to go back and cover that. 1B, we want to put the property address the property is located. So a common street address, the city, the county, of course it's in California, and then the zip code. We also have a place for the assessor parcel number. Not required. It's nice to put in there. It forces you to go into Realist in your MLS to look up the assessor parcel number on the tax rolls. And that also then forces you to see who, at least according to the county assessor, is the owner. The reason that's nice is every now and then you have a person who's on title or record who doesn't claim to be the owner. I once had an agent that wrote an offer, got a counter offer back, looked at the name of the counter. It didn't match up with the tax rolls. Lo and behold, the property owner's tenant listed the property. They thought they could sell it without the property owner finding out about it. So, funny, we know that could never work because of escrow and title insurance. But let's face it, a lot of tenants don't understand how everything works. So they thought they could have pulled a fast one. Always good idea to put the assessor parcel number. If you're ever writing an offer on vacant land, of course, we have the vacant land purchase agreement. But if you are writing an offer on vacant land, you may not have a street address, or you might not even have a street, right? It could be a piece of vacant land that not on a street. You can use the assessor parcel number to identify that property. It is a sufficient description to identify that property against all others. I once took a CE class where they said, well, you can't use the assessor parcel number. Wrong, you can use the APN, right? Purchase price. So we want to write out both in alphabetic and in numerical form. If you just write it on in numerical form, it will automatically spell it out in zip form. So that's really nice. So just like you would do a check, right? You write it both in alphabetic and numerical, if any of you still write checks, right? And then D, close of escrow will occur on, now you have a choice. You can either do a specific date or days after acceptance. Remember the little word in there inside the parentheses on line D is an or. You don't do both. It's one or the other. The reason you don't do both is you're never going to get them right. You can't sync them. If I was to say it's going to close on October 5th or October 6th, we're looking at what? Maybe a 45-day escrow, right? Well, it could take a couple of weeks to get final acceptance, particularly if you're writing an offer on a lender-owned property. So I don't like the specific date, because if it does take a while to get a final acceptance, if you put a specific date in there, your 45-day escrow may then turn into a 30-day escrow. And most of our sellers, and even most of our buyers, and including many of our sellers, we're thinking days of escrow, right? So my recommendation is just check the box and put in days. Now, under paragraph 2, we have our agency. And you'll notice that you've already disclosed agency to your buyer and seller. Okay. Now I'm going to be talking about this as if you are a agent writing this offer on behalf of a buyer. We know that agents who list properties have to give that AD form, agency disclosure form, before they list the property. I know many agents give the AD form right before the buyer signs this offer, which is at the last possible moment, you can have the buyer sign the AD, agency disclosure form, and still be legal, right? My recommendation is get that agency disclosure form signed by your buyer before you start showing them properties, okay? It's going to give you more protection. You cannot legally claim that buyer as your client unless you first disclose agency to them. So if you want to call your buyer your client and you're out there showing properties to your buyer, you better have signed that agency disclosure form with them. Now remember, that agency disclosure does not create agency. It's not a contract, it's simply a disclosure. You create agency with an agreement. It can be a verbal agreement, it can be a written agreement. The written agreement being the buyer representation agreement, right? But you do need to disclose agency as early as possible. So please do it before you take the buyer out and show them properties. Now we go into the agency confirmation. This is a little confusing since they added the sales licensee's name as well as the broker's name. So to try to keep it as simple as possible, you are representing the buyer. So in that second subparagraph under 2B, you will write your broker's name. And then underneath that, where it says buyer's agent, you will write your name. And then you and the broker are going to elect whether you are representing just the buyer or buyer and seller as dual agent. Whatever the broker is, you are. You cannot be representing the buyer and have your broker be a dual agent. You cannot be representing the buyer and have your broker represent the seller. Okay? Whatever your broker is, you are. So if you're the only one working with the buyer then, or you're representing the buyer exclusively, then your broker needs to do the same. You are also to fill in the seller's brokerage firm at the top of 2B. So if the property is listed by another brokerage company, you would put that brokerage company there where it says seller's brokerage firm, and then check the seller underneath it. And then you would put the name of the listing licensee, and you would check the box seller's agent. So they are representing the seller, you and your broker is representing the buyer. If you're writing an offer on one of your company's listings, in other words, somebody else in your office, and I don't care if it's in the location that you are or a different location, if it's your brokerage company, okay, and they have the listing and you have the buyer, everybody is in dual agency. So seller's brokerage firm, same company as you, buyer's brokerage firm, same company as you, everybody represents both buyer and seller. So anyway, I know a lot of you are familiar with agency. Hopefully, I haven't bored you too much if you understand this. If you have questions about agency, we'll cover it at the bottom of the page. And then C, potentially competing buyers and sellers, the PRBS form. This is not required by law, but it is required under the contract. So again, you want to make sure that the buyer has signed that PRBS form before you write this offer. Because the PRBS form allows you or requires the buyer to agree to go into dual agency if you have to do so, you really should get the PRBS form signed by the buyer before you show them properties. So my recommendation is you meet with the buyer before you go talking to them about what property they like to see, before you take them out and show them properties, have them sign that agency disclosure form, and then have them sign that PRBS or possible representation of more than one buyer or seller. Get those two forms signed early on, then you know you're in compliance and you'll have the protection of both of those forms. Now, moving down to finance terms. Dealing with the initial deposit. Okay? First question I always get from people is, how much should the deposit be? Well, there's no rule on this. The larger the deposit, the stronger the offer will look for the seller. So we would want to encourage our buyer to come in as big of a deposit as possible. Remember, a deposit is not legally required. It's certainly expected by the seller. You can have an enforceable agreement with the seller and your buyer without a deposit. Although I don't think your seller is going to accept an offer unless there is a deposit, because it's certainly expected. So getting back to the question, how much should the deposit be? My recommendation is $10,000 or less. The reason I don't like to go over 10,000 is because 10,000 is the limit for small claims court. So if your buyer and seller get into a dispute in escrow, the buyer wants to cancel, but the seller won't refund the deposit. Some of you have experienced situations like this, right? Your buyer can go into small claims court. That's what? Judge Wapner, Judge Brown, Judge Judy, I mean, whoever you watch, right? But they can go into small claims court. They can be in and out, COVID notwithstanding, in about 45 days. and they don't have to hire an attorney. But if they go above $10,000, now they have to go into superior court. That could take years because the criminal calendar gets priority over the civil calendar. And they have to hire an attorney, which makes it a lot more expensive. Now, some of you, before you put this in your chat, some of you may have a situation where you've got this really expensive property and you think it deserves more than a $10,000 deposit. Here's my suggestion. If you have a situation where you're going over $10,000 in the deposit, consider encouraging the buyer and seller to initial the arbitration clause. Here's my thinking. Arbitration is outside of court. You sit in a room with the arbitrator and the other party. You explain your situation to the arbitrator and they make a decision. It's kind of like people's court, only without all the judicial trappings of a courtroom, right? You're in a conference room. Now, if you want to bring an attorney in, you can, but you don't have to. And my thinking is, if you've got a property that warrants a $25,000 deposit, I'm just saying $25,000 because that's a lot of money, then you probably have a buyer and a seller who are sophisticated and educated enough that they can probably go into arbitration on their own and explain to the arbitrator themselves while they're entitled to a deposit, right? So again, you don't have to lawyer up. But my book, all you're trying to show is good faith here. It's not the consideration. The consideration are the exchange of promises between the party. I think in most cases, a deposit of up to $10,000 is sufficient. Now, the language, which I often refer to as the default language, what does it say if you don't check a box? Well, it says that the buyer will deliver the deposit to escrow with electronic funds within 3 business days of acceptance, which means you don't touch the deposit, you're never in receipt of trust funds, you avoid all that trust fund handling risk, and your broker is very happy. But if you want to be foolish and check 3A2, now you're collecting that deposit, which means you have to log it in the form of a personal check, and then you got to deliver it to escrow within 3 business days after acceptance. This is not going to make your broker happy, and this puts you in greater risk. So don't do that. Just let the form work itself under 3A1. Secondly, since the funds are being delivered to escrow electronically, there is no check. I know we still have some dinosaur agents out there who insist on a copy of the deposit check for their files. Remind them, this contract was changed over 10 years ago. We don't have checks anymore, okay? We don't collect them. The buyer delivers the deposit to escrow. Well, can I make a copy of the check anyway? If you make a copy of the check, you're in receipt of trust funds because you put it in your photocopier. How many of us have forgotten something in the photocopier? Yes, you forget the check in the photocopier. What do we call that? Commingling. You lose your license for that. So please, have the buyer deliver the deposit to escrow. If they don't like electronic funds and they want to do it with personal check, then check the personal check box. If they forget to check the personal check box, but they deliver it by personal check because they can't figure out how to do it electronically, have you voided the contract? No, you're in substantial compliance. I think you're okay. The key here is don't you dare touch that check. Your broker will not be happy with you, all right? And we want happy brokers because unhappy brokers, well, that's like having an unhappy dean at Mount Sac. That's never a good thing. Okay, now under 3B, increased deposit. Not a good idea. One, it creates more work and risk for you because not only do you going to make sure that that increased deposit gets in, you also have to give that CAR form RID, receipt for increase of deposit, when that increase of deposit comes to escrow, and invariably you're not at escrow, so now you're in violation of what you're supposed to be doing in the contract. And it means that the increase of deposit cannot be used to liquidated damages if the buyer and seller have initialed the liquidated damages clause. So you create all kinds of work for yourself. You've increased the risk and you've made your contract more complicated. So please don't do increase of deposit, okay? You are acting against my recommendations. Why does CAR have the paragraph in there? I guess somebody on standard forms wants to keep it in there, okay? But you're asking for problems. Now, C, if you have an all cash offer, that means no loan, you will check the box for C, and then you must also attach proof of sufficient funds, okay? You have to attach that to this offer. If you're not going to attach it to the offer, then you have to check the second box under C as well. It says the buyer will, within 3 days, deliver that verification. This is just the opposite of what we're going to see on the next page. Remember that paragraph that says you will get that pre-qualification letter, right, within 3 days? Or remember that paragraph that says the buyer will show that they've got closing costs within 3 days. If you check the box there, then it's attached. Here, it's supposed to be attached unless you check the box. Then you have 3 days. In other words, it's opposite. Why did CAR do that? Why did they say CAR make this paragraph the opposite of the other 2 paragraphs? I don't know. I don't know why CAR does some things. But the good news is when the new contract comes out next year, my understanding from the drafts I've seen, they're going to make them the same. I just don't know what same they're going to be, but they're going to be the same. So at least that will take away some confusion. Now, going down into the loans. Well, this paragraph says it will be a conventional loan with a fixed rate. Now, if you're going to go government, then you need to check whether it's FHA or VA. I don't think it's a big deal to go from a fixed rate to an adjustable rate if buyer decides they can get more loan at a cheaper rate because they're going adjustable rate. I don't think that's fatal. But if you're going from conventional to government and you don't disclose that to the seller in the offer, I think that's a material breach. I think that writes right up there with misrepresentation, maybe intentional misrepresentation, which would be fraud. So please, if you're going government, check those boxes. If you're asking the seller to carry back paper, check that box, include the SFA form, seller financing addendum. And then it's a good idea to tell them what rate you're getting, okay? So if you're getting a fixed rate at 3.5 or whatever rates are right now, go ahead and put that in. You know, it makes your offer look stronger because the seller's going to see, oh, yeah, they're looking for a fixed rate at 3.5 or 3 3/4 or 4 or whatever loan you're getting, and they're going to be paying 1 point. Oh, this agent and their buyer have done a little research on their loan. So it's going to make your offer stronger. Another advantage of that, it actually protects your buyer. If we were to have a financial calamity, and let's say your buyer was thinking about a 3 3/4% loan, but let's say rates went up to 6%. I mean, it just, something happened in the market. But your buyer has now released all contingencies. And the seller wants to keep the deposit under the liquidated damages clause. I think your buyer's got a really good argument before a small claims court judge to say, Your Honor, when the parties entered into this agreement, rates were at this rate. This is what we agreed to. Things happened in the market that were completely unforeseen. I should be able to cancel and get my deposit back. And I think you'll find that's a strong argument with small claims court judges, okay? So it actually does protect your buyer. Last comment on this. I once had a situation where I got an offer. They didn't put anything under the loans. And I asked the agent, what kind of loan are they looking for? You know, you didn't fill out the loan information. He said, well, we don't know what kind of loan we're getting yet. Then I looked at the agent and I said, then how in the world did you come up with this pre-qualification letter, right? If your buyer is preparing or getting a pre-qualification letter, and it's always a recommended practice to get your buyer pre-qualified or pre-approved before you start showing them properties, then you know what to put in here. It makes your offer stronger. It makes you look more professional. And I think it actually protects your buyer. Same thing with the second loan. Now, if you are going with a government loan, FHA or VA, again, we have some additional addenda. First of all, we have the FVA form. That is the form that you're going to give to the seller, asking the seller to make any repairs that is required, or in the case of a VA, asking the seller to pay those closing costs that were required by VA. That's the FVA form. Also, because there are some additional rules and regulation with government loans, we have to give the FHA VA a mandatory clause, which is the FVAC. All right. So just two more documents that we have to do if we've got an FV or a VA or a FHA loan. If you have more questions about this, obviously you're considering dealing with FHAs and VAs. What I recommend is you get yourself a lender who's experienced with FHA and VA. I haven't done a VA in years. I haven't done an FHA in even more years beyond that, but they can be a little complicated. So sit down with your lender, have them give you a 30-minute primer on, or maybe 45-minute primer on how to work FHA and VA. They're happy to do that for you. E, any additional financing terms. So you're asking the seller to pay some closing costs. This is a good place for it. And this is where agents are looking for it. You could put it in page 3 if you wanted to. We'll get to page 3 in a little bit, but this is where they're looking for it. I once had a broker who tried to tell me that, you know, the reason agents don't put closing costs here under E, they put it on page 3 is they're trying to hide it. I was feeling a little surly that day. I said, so your clients only read the first page of the contract? I mean, stop it. But if this is where agents are looking for it, be a good agent yourself and put it there. F, balance of down payment, and then G, the total price. Now, A, B, C, D, and E, and F added up will equal G. So it's A plus B plus C plus D plus F equals G. If you're using zip forms, it will automatically add up for you. It's great. But what if you're out in the field? You're handwriting this. How do you deal with it? Here's how you have to do it. You're going to have a loan amount, whatever that loan is. 80% loan, 90% loan, 95, whatever. You're going to have a loan amount. Put that loan amount in D. Right? That's the first thing you do. That's your loan amount. That's the amount that your buyer is going to borrow. You're going to have a deposit up in 3A, 5,000, 10,000, whatever it is. Put that in there. Then this is how you do it. You take your purchase price, you subtract A, you subtract D, and that will equal F. So G minus A minus D equals F. I'll say it one more time for you. G minus A minus D equals F. It's the only way you can do it out in the field, okay? Don't try to come up with your own little equation. I can't tell you the number of contracts I have seen where you add the columns up and they don't equal G. If you want to look foolish to the seller and the listing agent, have your columns not add up. It's the worst thing you can do because you look foolish, right? So again, you want to create the most powerful professional impression to that other agent, to that seller. So your contract has to look good. So again, use zip forms because it's all typed up and it adds it up for you. That's really sweet. But if you're out in the field, and sometimes that's the case, you've got to write an offer on the fly like we did in the olden days. And yes, I am that old. I've over 4 decades of this. That's how old I am. Got to make sure your columns add up. All right, so at this point, we finished the first page, and now I'm going to go up and go into my chat. Let's see. Rebecca, I have never had a buyer sign the AD before showing them the property or when I'm in escrow. What power does the form have if we were to decide to go with the listing agent? Okay, so the very first document your buyer or seller signs must be the AD form. The law requires it. It's Civil Code 2079. Failure to do that means potential loss of commission. So that's rule 1. Second, we never have a problem with the seller because we get all the paperwork signed first up, right? So just make sure when you're on a listing appointment, do the AD form first. Now, with the buyer, and Rebecca, I think that's what your question regards to. I know most agents get the AD form signed right before they sign the offer, right? Okay, let me tell you a true story. I used to manage an office with over 400, maybe 450 agents. It was huge. We had 5 locations. I was the head manager, right? So Monday morning was always a disaster. I would come in and I just had emails and phone calls. So called this one agent back. Agent's threatening to sue us, take us before grievance and ethics boards because one of our licensees, one of our agents, stole his buyer. So I said, let me talk to my person. So I called up my agent. She was holding one of her own listings as an open house. The buyer came in. She asked the buyer, are you represented by another agent? The buyer said, I've seen other properties with other agents, but I am not being represented by an agent. She wrote the offer on her own listing, double-ended it, was in escrow. She's going to get the whole commission. She's happy. Okay, now I have to go back and talk to this other agent from a different company, right? So I call the other agent up and I say, okay, our agent's understanding is different than yours. First of all, do you have a buyer representation agreement? He says, no, I don't need one. I'm still going to sue you. Okay. Because I knew if he had a buyer representation agreement, that buyer broker agreement, we had to give the buyer back to him, right? Because he's got an agreement. But he didn't have a written agreement. So now I asked this other agent, will you please send me over a signed copy of the AD form with this buyer? And he says, I don't have one. And I say, ha ha, you lose. He said, what do you mean? I said, 2079.14 of the Civil Code says you cannot claim a buyer as your client unless you first disclose agency to them. And failure to do that is loss of commission. You lose again, go away. And he did. So the key point is, if you have a buyer and you're out there showing them property and you're referring to them as your buyer or your client, but then they write an offer with another agent and you want to say, wait a minute, that's my buyer. You stole my buyer. A good attorney's first question is, show me your AD form. Because if you didn't disclose agency to your buyer, you have no claim to that buyer, nor do you have a claim of commission. So for that reason, the law and good policy says you want to disclose agency as soon as possible or as soon as practical. So that's why get that AD form signed then. And as long as you're getting that AD form signed then, my recommendation is go ahead and get that PRBS form signed, because that PRBS form says that if you're writing an offer on one of your company's listings, so your buyer has to go into dual agency, your buyer is agreeing to do that. Your buyer can't say to you, no, I don't want to be a dual agent. I want single agency, and I'm going to go to somebody else and have them write an offer. They can't do that if they sign the PRBS form. So get that AD form, get that PRBS form signed early on. It'll protect you. All right. And that's all the questions for 1. I think. Let's see. We might have another one coming in. Hold on. Oh, Rebecca likes my explanation. That's good to hear. All right, so now we're going to go into page 2. And the good news is I talked the most about page 1. Not a lot to talk about after page 1 because it's pretty much all written for you. You still need to know what it says. So top of page 2, verification of down payment and closing costs. You have 3 calendar days to get this to the seller after acceptance of the offer. Now, if you want to include it with the offer, you can by checking the verification box. But if you don't, just remember you have 3 days. This offer is contingent on the property appraising. Now, if you want to remove the appraisal contingency, which I think is a terrible idea, you can by checking the box. Remember, the basic rule is when you have a question as to whether check a box or not check a box, probably don't check a box. Whether you have a question of leaving the days as they're pre-printed, as you see here, 17 days in paragraph I, or changing it, leave it as it is. If you start changing things, if you start checking boxes and not know why you're checking boxes, you're going to get into trouble, okay? Let the contract work its way like CAR wants it to. Remember, who wrote these contracts? Realtors. Who do these contracts protect? Realtors, right? So again, let the contract do its work for you. Now, all offers, unless you check the box, have an appraisal contingency, even all cash offers. So for some of you new agents, right, you have a listing, you've got a old curmudgeon over there representing the buyer. When you release contingencies, you can do it 3 ways. You can release all the contingencies, which is what I like. You can release all the contingencies except for, which is a little confusing, or you can release the contingencies one at a time, which is kind of frustrating and time consuming. Invariably, you're going to find the buyer releasing contingencies one at a time, and they don't check the appraisal contingency release. And you call up the other agent and say, hey, could you release the appraisal contingency? And they snap back, it's an all cash offer. There is no appraisal contingency. Yes, there is. You still have an appraisal contingency, even if it's an all cash offer. So don't want to have a situation 5 or 6 days prior to close and the buyer backing out based on an appraisal, and they can do it because they never released that contingency. So please get all contingencies removed. Then under J, loan terms. Okay? So within 3 days, you're going to deliver that pre-qualification or pre-approval letter. Again, we don't really have definitions for what is a pre-qualification or pre-approval, except pre-approved is better than pre-qualification, right? So I always have my lender write pre-approval rather than pre-qualification. Anyway, got to get that to the seller within 3 days, unless you check the box and then it's attached. This remains a loan contingency, okay? Loan contingency remains. It will be removed within 21 days, okay? So there under J3, we have 21 days for the loan contingency to be removed. Now, if you check J4, there is no loan contingency, which is scary. What happens when you have no loan contingency and your buyer can't get the loan? Well, then they're going to have to pay cash. Well, what if they don't have the cash? Then they're in breach of the contract and they can be sued for breach. And that's no fun, right? So please do not use no loan contingency unless you have a buyer who is prepared to pay cash or has the ability to pay cash. Because even if you have a golden or platinum buyer, borrower, whatever, things happen, and sometimes they can't get a loan, right? Now, 5 is a little confusing. It's really more of a disclosure than anything else. Lender limits on buyer credits. So we all know, or hopefully know, that the sweet spot for a loan is 20% down. If the buyer comes in with 20% down, hooray! If they come in with more than 20% down, it's yip, yip, hooray, right? Because lenders love it when buyers come in with 20% down, or even better, more. But if a buyer is coming in with less than 20% down, now you're going to need some kind of a guarantee or insurance on that loan, right? You need PMI, you need FHA, MMI, you need VA guarantee, you need something, right? So this is the way it's going to work. You have a buyer who writes an offer, 20% down. Hooray! They're asking the seller to pay, I don't know, $8,000 in closing costs. I'm just making up numbers here, right? Well, the buyer's closing costs are only $6,000. The seller's agreed to rebate back $8,000, which means the buyer's not actually coming in with 20% down of their own money. They're getting $2,000 back from the seller. So it's really like a 19.95% down. It's not 20% down of the buyer's money anymore. And the lender's going to squawk at that. What this paragraph says is that excessive credit will go back to the seller and there'll be no adjustment in the purchase price. All right. So again, this is a lender thing, not something you and I can control. It's just letting the parties know the facts of life when it comes to lender loaning and down payments. K, buyer stating financing. The seller's relying on the buyer's representation of the financing. Remember I said before, this contract says it's going to be a conventional loan. You shift over to an FHA or VA, this contract says the seller relying on it being conventional. You shift over to an FHA VA. If you were intending to do that all along, or your buyer was intending to do that all along, that's misrepresentation. Intentional misrepresentation, also known as fraud. You don't want to do that. So again, be very truthful on that first page. Now, if you have a buyer who needs to sell their old property first, you would check 4B. Now, typically it's not the case, so you just say that we're running 4A, which means it's not contingent on the buyer selling their old property. But if you have a buyer that needs to sell their old property, then you check 4B, and that means you have to attach the CAR form COP, contingent of purchase, okay? Now, in that COP form, it will identify the buyer's property, whether it's listed or not, whether it's an escrow or not, who it's listed with, who it's an escrow with. So the seller and the listing agent can contact escrow and find out what the status is. Now, I know we don't like to see this box checked, but if your buyer's property that needs to be sold not only is an escrow, but it's on day 30, and all contingencies have been removed, and they're coming in with 30% down, you've got a really nice offer here. But if the buyer's property hasn't even been listed yet, this offer sucks, right? So that will tell you how strong or how weak this offer is based on this contingency. One important point. At the very bottom of the COP form, used to be paragraph 6, I think it's now paragraph 8, they keep adding paragraphs. There is a provision on what to do if another offer comes in. So here's the scenario. The default language in the COP form says that if you're in escrow with this buyer, let's call him buyer 1, and another offer comes in from buyer 2, you can give buyer 1 a 3-day notice. That's where the old 72-hour clause phrase came from. You can give buyer a 3-day notice to release this contingency under 4B, or you get to cancel and go with buyer 2. If, however, the box is checked at the bottom paragraph of the COP form, then buyer 2 has to stay in backup position. So if you get an offer with the COP form, it's very important to read that whole form, including the last paragraph. If you don't understand what's going on, sit down with your manager or broker, have them explain it for you, okay? If you still don't understand, then call the CAR legal hotline. They'll walk you through it. Don't call me. I don't give legal advice. I just teach. Okay, paragraph 5. If you want to add any addenda, like the CAR addendum page, which is there at the top right, you could do that. What is that addendum page? It's just a form with a bunch of lines on it in case you don't have enough room in this form. Okay? If you have any advisories, you can do that under 5B. And then paragraph 6 is your other terms. Now, what I like to do with paragraph 6, if there's any paragraph or clause that I want to eliminate in this contract, that's a good place to do it. Remember I said paragraph 26 doesn't allow the assignment. So here in paragraph 6, I can write in paragraph 26 is deleted from this agreement. So I have to do not cross out sections or lines. You're going to get yourself into trouble. Just simply write in paragraph 6 what's being deleted or what's being added or something like that. The other recommendation I have is do it in columnar form. In other words, every thought gets a new sentence. So you have a 6A, 6B, 6C, 6D. What if you have a 6D, 6E, or 6F? Then go up under 5A, check the box for addendum, and you got lots of lines in the addendum, so you can go further there. The reason I don't want you to run everything together in paragraph 6, it's harder to see things, it's harder to read things, it's harder to understand what's going on. You want to make this offer as simple and easy to understand as possible. You get into escrow, and if the other party doesn't understand what they signed, you're going to have a problem escrow. You're going to have an upset agent on the other side, and you're going to have a miserable escrow, and you're going to have derogatory things said about you in the future. Don't go there, right? Make it nice, easy to understand. Paragraph 7 is for allocation of costs. Now, 7A1, who's going to pay for an NHD or natural hazard disclosure report? You need one, right? I know the statute says that if the seller is exempt from the TDS, and we know which sellers don't have to do a TDS, right? Probates, lenders, that kind of thing. If the seller's exempt from a TDS, they're exempt from an NHD. But then the statute goes on to say, unless the property's in an NHD zone, then you have to disclose that. But of course, you don't know if it's in a zone or not unless you get an NHD report. So most sellers will pay for an NHD report. For you new agents, it's like $100, $125, right? It's not that much money. Next line, who's going to pay for any other reports? And you have 2 lines for that. Now, the most common one in 7A2 is termite, which is actually a wood-destroying pest organism report. But since nobody can remember wood-destroying pest organism, we just write termite, right? And that's good enough. Prepared by whoever. So if you want the seller to pay for an inspection report, you put that in there. I don't recommend checking the buyer boxes here. And the reason for that is you're trying to get the seller to agree to do certain things, namely sell the property at a certain price. The seller doesn't care if the buyer wants to pay for something or not. So there's no reason to check buyer. If it doesn't get paid for, it doesn't get paid for. Buyer gets the property. So what? If the buyer wants to do an inspection or pay for inspection, they can do that on their own. Paragraph 14 allows the buyer to do whatever investigations, inspections they want to. They're paying for it, they can do it. So you don't have to check the box for the buyer to do it. But if you do check the box for the buyer to do it, the lender's going to see this contract. And the lender may throw into one of the loan conditions that the buyer pay for whatever report that is. Now the buyer's stuck paying for something. And what do we know about buyers at the close of escrow? They always have less money than they thought they were going to have, right? So just don't do that. Now, I know some agents out there under 7A2 try to get the seller to pay for Section 1 work in a termite report. What is Section 1? Well, Section 1 means that there are bugs eating the wood in the house. That's Section 1. Section 2 is a condition that could lead to infestation. So Section 1 is infestation. Section 2, something could happen. In other words, earth to wood contact. If you've got dirt or a wooden post in the dirt touching the house, that could be an entry point for subterranean termites. So that's Section 2. It's basically a maintenance item. But Section 1 is where the house needs to be fumigated. All right. Now, when you talk about fumigations or repairs, if the infestation is on an exterior piece of wood like dry rot or wood boring beetles, then that wood can be removed and replaced. Not a big deal. Hopefully it won't cost you more than $1,000, $1,500. If, however, you have infestation in the house, then the house typically needs to be tented. Now, that may cost between $4,000 and $6,000 depending on the size of the property. But I've actually seen termite reports. One was for $38,000. The other was for $42,000. I mean, those are deal breakers. It's problematic to get the seller to pay for a repair when you don't know what that repair is going to cost. So that is why you should never put in the contract seller to pay for repair work if you don't know what the cost of that repair work is going to be. You're setting yourself up for problems and a lawsuit. So what do? Here's my recommendation. Have the seller pay for the report if you want them to pay for the report. The report comes back. If there's infestation, you give the seller a request for repairs. Now, a good agent will tell their seller, look, seller, your house has termites. You either pay for it with this buyer and we close, or you say, no, this buyer's not going to give the loan because the lender's seen they're going to ask for a copy of that termite report because they know there's one because it was specified here in the contract. They're going to see the infestation. They're going to require that that property be fumigated. And if the seller won't do it, then this escrow is going to cancel. Seller's going to go back into the MLS. Eventually, they get another offer, and they're going to have to give that report to that buyer, and that buyer is going to ask for a request for repairs. So seller, save yourself some time and just do it now. Okay, so if you don't like that one, because I know some of you are not going to like it, here's another one. Leave it blank. Don't put anything down for 7A2. Do you know of termite companies that will do free inspections? Of course you do. And if you don't, somebody in your office does, right? So have the buyer get the property inspected during escrow, during their 17 days in paragraph 14. If they find infestation, buyer can then do a request for repairs. Same scenario. If seller doesn't agree to do the repairs, buyer cancels, seller goes back on the market, they're going to have to give that report to the next buyer. And that buyer is going to ask for the repairs anyway, right? However, if the seller is just being a dodo and doesn't want to do the repairs and doesn't care, buyer could still buy the house with the infestation, because since the termite inspection was never mentioned in the offer, the lender doesn't know that the inspection was done. It didn't cost the buyer anything to do the inspection because they did it for free. And if the buyer wants to buy the house with termites, they can, but they don't have to. The buyer kind of has the best of both worlds now if they want it that way, right? And the nice thing about you, the agent, is you got a copy of that report. The buyer can never come back and sue you because the house has termites, because it was disclosed to them in the termite report. So it's a win-win, right? Now, 7B, government requirements and retrofit. First of all houses in California required to have a smoke alarm, required to have a carbon monoxide detector unless the house is exempt, meaning it's an all-electric house, no attached garage, no fireplace. And they're required to have their water heater braced. So those things are all required. If you don't have those in your house, and I'm speaking to you, we're in this class, it's a $100 fine, right? So, but you're supposed to have it. When the property is transferred, does the buyer want to ask the seller to pay for those things? If they don't, leave it blank, noting that it's going to show up on the appraisal report. So you're going to have either a request for repairs or the buyer's going to have to pay for it, right? So I just checked the seller in 7B1. Now what I'm going to do is go to the top of the next page because it's part of the same paragraph, and then I'm going to take questions. So number 2 at the top of page 3. If you are in a city that requires a point of sale inspection, and some cities do, okay? So Laura can give you the name of your GAD person, Government Affairs Director, and they can give you a list of all of the cities that do have government inspections. They're going to charge you for that. It may be $75, maybe $150. I don't know. Who's going to pay for that? I always have the seller pay for that because I don't know if they're in a city or not. If you're a listing agent, you're listing the property, you need to find out whether your listing is in a city that requires an inspection and what that fee is, right? Your GAD person can give you that information. Last, if the city requires other retrofits, and the most common here is low flow water fixtures, showers, toilets, that sort of thing. If that's required, who's going to pay for it? Now, this really only becomes a big issue if you're in a city that has these inspections. If you're in a city that doesn't have the inspections, well, you know, maybe the appraiser will notify the lender. Maybe the lender will require it. Maybe they won't, okay? Remember that water conservation devices? If the house was built since 1994, it should have water conservation fixtures because the law came into effect in 1994. If the house is older than that, then you may have an issue with low flow toilets and things like that, because if it has the original plumbing or the original plumbing fixtures, they may not be low flow at that point. All right, so I've covered all of page 2. Did I go backwards? I did go backwards. Let's see what we have in the chat room. And let's see, can you explain both all cash offer and no load contingency? It only allows to check one at a time. Okay. Not sure why it's doing that. Because you could have an all cash offer and still get a loan. I guess if you check all cash offer, then you wouldn't necessarily have to have a low contingency But you can make an offer on a property with a loan and not have a loan contingency. So if Zip Forms is doing an automatic fill, I could see where the no loan contingency would get checked if you're all cash, but the all cash offer shouldn't get checked if you're just going with a no loan contingency. But I'd actually have to go into Zip Forms and play with it to find out. But play with it, see if you can do one and not the other, but then one with the other, all right? Termite report with Section 1 clearance, is it good to put? The answer is no. You see, you're going to run into problems if you ask the seller to repair something if you don't know what that cost is going to be. Because invariably, the agent's going to tell the seller, oh, Section 1 clearance. Well, first of all, it's not a clearance. It is a notice of completion. You know, you run into problems when you try to tweak the form. You're going to get into the unlicensed practice of law, and you don't want to do that. But a lot of agents will tell their seller, oh, it's no big deal. It costs maybe $4,000. And then lo and behold, you've got subterranean termites and you get that $42,000 repair cost. See? So again, never a good idea to ask the seller to do the work. You want to ask the seller to pay for the inspection, great. Or if you want to do my plan B, just have the buyer get a termite company, because you know the termite companies, they'll do it for free. Termite companies don't make their money inspecting. They make their money on the work. So they'll come out for the most part and inspect for free. Since it's not in the listing agreement, or sorry, since it's not in the offer, it's not in the contract, your lender doesn't know about it, and now your buyer and seller can negotiate who's going to pay for it. Okay, Eva has a question. If an agent has been showing and writing offers for the buyer attends an open house and likes the house. The listing agent told the buyer the only way he can accept the buyer offer is that he write the offer himself. The transaction closed. What recourse does the original buyer agent have, and what time period can the agent go back and claim compensation? Okay. I believe you're going to have at least 2 years. I'd have to review the statute of limitations, but I believe you're going to have at least 2 years. You may have longer than that, but I believe you have 2 years at least because, okay. Here's the issue. That buyer needs to be your star witness. If you're the agent that showed the buyer or were working with the buyer, that buyer's going to have to testify at a grievance hearing that the listing agent told them the only way they can accept the buyer offer is that they write it themselves. If that buyer's willing to testify before a ethics panel, an ethics panel, then you have a case. But I'm pretty sure you're going to have I'm pretty sure it's going to be at least 2 years. So if it's not over 2 years, I would go ahead and file a grievance against that agent. Just be sure you've got cooperation from your buyer. They're going to testify. Without the buyer's testimony, you don't have much of a case because it's going to be one of those he said, she said things. That listing agent is going to say, I never said that. You're going to say, well, he did say that because my buyer said that, but that's hearsay. You need the buyer to testify. All right. All right. So let's move on. We now into paragraph C at the top of page 3, which is escrow and title. First, who's going to pay the escrow fee? And we typically check both boxes under C1 because in Southern California, the buyer and the seller split the cost of escrow, but it's not split equally. So I know some agents write 50-50. You see, if you have a buyer who's getting a loan, there's a loan escrow because you have an escrow between the borrower and the lender. But you also have an escrow between the buyer and the seller. So in a typical sale, you've got 2 escrows going on. So I like to write each to pay their own under C1A. Each to pay their own. So you're going to kind of split it, but not really split it equally. Okay. Then who the escrow holder is going to be. Now, I know some of you like to put in seller's choice. I don't like seller's choice because you still have to agree on who it's going to be. And invariably, you run into problems there. There was actually a termite company years ago down in San Diego called Seller's Choice. I thought that was kind of funny. You're going to be talking to this listing agent, right? You're going to call them and ask them if the property is still available. You're going to say, hey, I'm writing an offer. And are there any other offers on the property, right? So you're going to have some kind of communication with them. That's a great time to say, hey, do you have a favorite escrow, title, home warranty, termite? And you're going to get that information. Here's what I like to do. If I find out that the listing agent loves ABC Escrow and they love XYZ title, if I don't have a problem with ABC Escrow or XYZ title, I may sit down with my buyer and say, hey, no, you and the seller could care less who escrow and title is. I'll just explain what they do because they don't know what they do. Matter of fact, they don't know who the companies are, right? But then they'll say, you know, this listing agent, they like ABC title, escrow, and they like ABC, XYZ escrow, or whoever it is, right? If we put them down, and I think they're okay, I don't have a problem with these companies, this agent is going to like our offer more. What do I know about making the listing agent happy? If the listing agent likes my offer, they tend to be a little easier to work with. And sometimes they help try to get my offer accepted. So you can use that as a negotiating point, right? What I wouldn't do is I would never counter out an escrow company, a title company, a home warranty company, because if you ever get into a problem with that buyer or seller and their attorney wants to make your life miserable, they will ask their client, why was ABC Escrow so important to you that you were willing to lose the deal by countering it out? Because that's what you do when you counter. You're risking losing the deal. And that seller will say every time, or that buyer will say every time, oh, my agent made me do it. And that looks like a RESPA violation. So if you want to negotiate escrow and title and home warranty with the other agent, okay, just be sure you're not doing it for financial gain. Remember, kickbacks are illegal, violation of RESPA. But more importantly, if you're going to be doing it, do it verbally, unless your client does not like that escrow company or title company for their own reasons. And there are some sophisticated buyers and sellers out there that do have favorite escrow and favorite title companies. So, okay, I make that disclosure right up front. Now, under D, other costs, county transfer tax, that's that $1.50 or $1.10 or yeah, $1.10 per thousand or 500 for 50 or 55 cents per 500, I guess is the DRE exam question. Anyway, seller traditionally pays that. If you are in a city that also charges a transfer tax, you can ask the seller to pay there. I always ask the seller to pay the HOA charges. I mean, it's their HOA, so I always check that box there. If there is a private transfer fee, again, I typically check the seller box there just because I don't know what those fees are, and I don't know how much they are except for D1, county transfer tax. So I'm just going to have the seller pay for them. So I just check the seller box. Seller doesn't like it, they can always counter it out. If you do want the seller to pay for something else, you can check the boxes in 8 and 9 there. But don't check those boxes unless you write something in. I see sometimes agents will check a box, then they don't write anything. Well, that's a sloppy looking offer, and it's going to impinge on your credibility. If you want the seller to pay for a home warranty plan, you can check the box in D10. If it's an older home, You know, it's a 60, 70-year-old home in Pomona or Covina or something with original appliances. Might be a good idea to see if the seller will pay for that. Sometimes they will. If you're not going to ask the seller to pay for it, then check the box in the paragraph below in bold where it says buyer waives the purchase of a home warranty plan. But then it goes on to say there's nothing to stop the buyer from purchasing one. Again, don't check the box buyer in D10 because the lender may end up requiring the buyer as a loan condition. All right. And let's move on. So paragraph 8 is what's going to be included or excluded. The basic rule is if it's attached to the property, it's included. If it's not attached to the property, it's excluded. If you have something that's not attached and you want to include it, then you would write it in under B3, 8B3. If you have something that you read in the MLS is attached, but the seller wants to remove it, then under 8C, you would write it in there. Again, you've read the listing. Hopefully the listing has explained what is and what is not included. If there are some items that are included that are not attached or be excluded that are attached, then you need to reiterate that here into paragraph 8B or 8C. Remember, MLS is not part of the agreement. However, even though 8A says what I'm going to say to the contrary, I will tell you, if the listing says that something's included, the washer and dryer, the refrigerator, and the buyer sees that, and it's not specified in this contract as being included under 8B, and the seller removes those. Yeah, it wasn't part of the contract. Paragraph 8 says it's not included, but a small claims court judge is going to say that's a misrepresentation. Listing agent, buyer's agent, you saw, or you should have seen, that the listing said that these were to be included. You didn't have them included in the contract. That's a misrepresentation on the part of the agent who took the listing and put it in the MLS. And that is going to be viewed as incompetence by the agent writing the offer. And we're going to have the two agents buy a new washer, a new dryer, and a new refrigerator for this buyer. And that's what the judge is going to do. So please reiterate anything that's included, excluded on flyers, MLS, etc. there in paragraph 8. All right. Remember, the flat screen is not included, but the bracket is included. All right. If the seller wants to remove the bracket, you have to check the box at the bottom of paragraph C. Right? If that is checked, the seller can remove the bracket. They have to patch the holes, but they don't have to repaint because that's what that paragraph says. All right. Then we get down to closing and possession. So the contract says that the buyer intends to live in the property unless you check the box. Then it might be purchased as a rental or a vacation home. 9B, if it is seller occupied, it will be returned or given to the buyer. Possession will be given to the buyer at 6 p.m. on the date of close of escrow. Now, if you want to make it earlier or later, you can. The basic rule is we never want buyers to move into a property early, nor do we want to have the buyer's personal property put into the property early. You're asking yourselves for problems, even though CAR does have agreements for both of those. Okay? Second, we never want the seller to stay in the property after close of escrow. Right? You're asking yourselves for problems in both those cases. However, there are agreements that allow you to do that. From a personal practice note, the only time I've ever allowed a seller to stay in the property late is if the seller is in their 80s and the buyer doesn't need possession immediately, sometimes you can get a much better price if you give the seller a few extra days to stay in the property. Commonly referred to as COE +3, close of escrow +3. You know, I'm not there yet, but I do know that people in their 80s, at that point, it's not about the money anymore. It's about convenience. They're in the 80s. They're not going to spend the money, right? They're in their 80s. But what they really want is convenience. So a lot of times they will be a little bit more flexible on price if you give them a little bit more time. All right, let me go up now into the chat. Oh, we don't have any chats. That's good. I'm doing a good job. All right, so now we're going to go to page 4. So if you do have a seller remaining in the property after close of escrow, the question is, are they going to be in the property for more or less than 30 days? If it's less than 30 days, that first box, the SIP form, seller in possession, you need to have that completed. If it's more than 30 days, then that second box, the RLAS, residential lease after sale, needs to be completed. You've got two different animals. In both cases, you have a tenancy, so you need to have an agreement. But if the seller's going to be in the property for more than 30 days, you've got some new issues. Rent, security deposit, insurance, etc., right? If it's for less than 30 days, issues aren't as great. But please make sure the buyer notifies their insurance company, because they're probably going to have to get some kind of a rider, because in both cases, it is in fact a tenancy. Now, I saw a question pop up. Let me see if I can get to that real quick in the chat. Okay, so long question. If an agent shows the builder's property to a buyer and register the buyer with the builder on the date of showing, buyer put down a deposit to reserve a lot, but after consulting with the buyer's preferred mortgage broker, buyer turn around and ask the mortgage broker to be their buyer's agent on the real estate transaction and mortgage or both. The mortgage company started to contact my broker and willing to pay a 50% referral fee of the total real estate commission in my office. They claim the buyer has no choice to choose. The buyer has choice to choose who to be their agent. The buyer has chosen her. Do we have to agree to it? No. Do we have a case against the builder and the mortgage company? Yes, you do. Okay. I would either have your broker send a very strong letter to both the builder and the mortgage company. Please reread that registration receipt that you received. When you bring a buyer into a new track, you register that buyer. They should be giving you something that is essentially a legally enforceable contract, typically to pay you a referral fee. Now, let me go back. You typically, in a new home subdivision, when you bring that buyer in and deposit them with them at that track, you are going to be the referring agent. You typically do not represent them. You don't write the contract. No, the builder is going to do that. They're going to pay you a referral fee for doing that. And that referral fee is typically around what? 2.5%, 3%, right? And they say, no, 2.5%, 3% is a commission. No, it's not. It's a referral fee. A referral fee can be at any amount. You can have a 6% referral fee. What's the difference between a commission and a referral fee? In a commission, you're the agent. You wrote the offer. Okay? You did all the disclosures. You represented the buyer throughout the transaction. In a referral, you turn the buyer over to somebody in exchange for the promise to have a referral fee. And most of these developers will be paying a referral fee in the 2.5%, 3% range, right? I know that may be the same amount that you often see as a commission. Remember, commissions are negotiable. I just put that in case Laura is listening, but it's still a referral fee. So no, you're entitled to 100% of what they promised, and it should be on that paperwork that you received. Review that with your broker, send a very strong letter to that developer, to that mortgage broker, okay, and then sue them, okay? I think you have a very strong case. Aha, Laura is listening. Well, Laura, I'm a lawyer, so I'm pretty good about not stepping in dog poo-poo. All right, so let's move on. Oh, got another one. I had to get my drinky down, Liam. Hold on, hold on. Always tough when you don't have a mouse. All right, you're very welcome, Joey. Anytime. All right, now, D is a little tricky. If you have tenant-occupied property, the property needs to be vacant for at least 5 days prior to close of escrow. Why 5 days? Well, that's your walkthrough. Remember your verification of condition that we're going to get later, or verification of condition of the property. You do your final walkthrough 5 days before close. So if the property has a tenant, the seller is agreeing to have the tenant out of there 5 days before close, right? If the tenant is still in the property when the buyer does their final walkthrough, notify escrow that closing needs to be extended because seller's in breach of the contract because the buyer is still in the property. If that causes the buyer to have additional loan charges for extending the loan, the seller should be liable for that because the seller has breached the contract. Now, the other thing you need to remember, our contingency period, right, for inspections, loans, 17 or 21 days, right? Most sellers don't want to give a 30-day notice. We're assuming it's a month-to-month tenant. Most sellers don't want to give their 30-day notice to the tenant until the buyer releases their contingencies. Now, if your seller's in a lease, they're in the lease, right? Seller's going to have to do cash for keys or something. Or the buyer's going to have to buy the property with the seller, with the tenant. Don't like that. But anyway, if it's a month-to-month, I know if tenants have been in the property for over a year, they typically have a 30-day notice. They don't if the buyer is going to occupy the property and it's a single dwelling. A house, a condo, not a 2-on-1, not a duplex, but if it's a single dwelling, the buyer's going to live in the property and it's a month-to-month, you only have to give a 30-day notice, all right? But the property needs to be vacant 5 days prior to close. Okay, so what I would do in my other terms is put the following language. Seller to give a 30-day notice to tenant immediately upon buyer releasing contingencies, escrow to close in 60 days or less. Here's why. Your buyer has a contingency period of 17 days for inspection and 21 days for loan. Then after that, you have 30 days for the notice. And then after that, you have 5 days, the property has to be vacant. So if we use the 17 plus the 30 plus the 5, we're at what? 52 days. If you're using the 21 days, 17, 18, 19, 20, 21, that's 4 more days. So now you're at 56 days. You cannot have a 45-day escrow if you have a property that the buyer's buying and has a tenant in there, unless the tenant has agreed with the seller to get out earlier. So again, write that in the contract. I'll say it again. Seller to give 30-day notice to tenant immediately upon buyer releasing contingencies. Escrow to close 60 days or sooner, all right? So you're going to have a 60-day escrow, but the reason you put that language in there it reminds the seller and the listing agent that they have a responsibility to, first of all, give the notice to the tenant and get the tenant out. For some reason, there's a lot of sellers and listing agents, the tenant's still in the property, say, well, the tenant needs to get out. And they go, well, I don't know what to do. No, it's the seller's responsibility to get the tenant out, all right? If, however, the buyer wants to take the property with the tenant, they want to keep it as a rental, then you check the box under D, which says tenant to remain in possession, all right? At close of escrow, seller's going to sign all rights, warranties, that sort of thing, and all instructions on how to operate those systems, the keys, garage door openers, all those gizmos, automation systems, things I don't understand, which is why I have a wife, because she understands that stuff really well. All right, paragraph 10, real simple. It merely reviews all of the statutory and other disclosures that have to be done. Pay attention to 10A4. What 10A4 says is if your seller is giving a transfer disclosure statement to the buyer, then they must also give an SPQ, seller property questionnaire. 10A4 says that if you have a seller that doesn't have to give a TDS because it's a REO, real estate owned, it's a lender property they've taken back in foreclosure, the lender has to give the ESD, exempt statutory disclosure. Now, I know we have sellers out there that don't like to do TDSs, right? You have to do a TDS, okay, if the law requires it. But you don't have to do an SPQ. Can a seller counter out an SPQ? Yes, they can. Can a seller who's a lender counter out an ESD? Yes, they can. You can't counter out the TDS. The law says you have to do a TDS, you have to do a TDS. But the SPQ and the ESD are by contract. So if you have an investor seller that doesn't want an SPQ, they can counter it out. If you have a situation where you have a lender-owned property, you might want to ask them, are they willing to do an ESD? If they say no, then suggest to the lender they might want to counter out the ESD, all right? Moving on, takes us to page 5. I think we have some chats. Let me get in those real quick. Not a disclosures class, but I'm happy to talk about disclosures. Okay. Can you type on the chat box? I can type on the chat box, but I don't know what you want me to type. Maybe you wanted me to type seller to give 30-day notice to tenant. Buyer. Okay, maybe that's what you wanted me to type. But again, I love clarity. I want everyone to know exactly what's in the contract, right? Is 30-day notice to all tenants. Okay, 30-day notice for month to month if the buyer's going to live in the property. It is a single dwelling, a condo, a house, not a 2-on-1, not a property with a rented out granny flat or something, and you're going through an escrow. The thinking is as soon as that for sale sign goes on the property, you have effectively given constructive notice to the tenant that they may be asked to move. So even if the tenant has been in the property for over a year, on a month-to-month, you only have to give a 30-day notice to the tenant. If the buyer's going to live in the property, it's a single dwelling, not a 2-on-1 or a duplex. It can be a condo, and you're going through an escrow. Let's see. Can I repeat the last part about TDS? Okay. You cannot counter a TDS. TDSs are required by the Civil Code, Section 1103. If, however, and we've seen these, right? Our investor sellers, they don't want to do a TDS. They claim they're exempt. They're not. Investor sellers have to do a TDS. Do they have to do an SPQ? If the contract says so. But that could be countered out. Same thing with lenders, only a little different. Note that lenders don't have to do a TDS. They're exempt. Probates don't have to do TDSs. They're exempt. But does a lender have to do an SPQ, or excuse me, not an SPQ, an ESD? The ESD is the first page of the SPQ. Under paragraph 10A4, they do by contract. Can the tenant, excuse me, can the lender seller counter out that ESD? Yes, they can. Okay, so they can counter it out. So you can counter out anything in a contract, but you cannot agree to not do something that's required by the law. So you always have to do an AD form because the law says you do, all right? If I'm selling my house, I always have to give a TDS because the law says I have to. So if the law says you have to do something, you have to do it. Just remember that. If the contract says you have to do something, well, if you counter it out, then it's not in the contract anymore. So you don't have to do it. Okay, so we now have the chat coming in. Oh, thank yous. I like thank yous. All right, so let's move on into page 5. All right, so if the property is in a condominium or planned development, then within 3 days, the seller has to request the HOA documents. Remember, we can't require the HOA to do something because they're not a party to this contract. I believe under statute, they're supposed to provide those documents in 7 to 10 days. All we can do is require the seller to request the documents. So seller needs to do those within 3 days. Paragraph 11, this property is being sold in its present condition, okay? As is. Unless the seller, either as part of this contract or in a request for repairs, agrees to make repairs. But the seller is agreeing based on the contract that you have in front of you to sell the property in its present condition. Not agreeing to make any repairs. However, under 11D, it says that the seller will disclose all known material facts. So anything that could affect the value of the property, seller needs to disclose those to the buyer. Just the seller doesn't have to repair them. Now, does the seller have to investigate their property? No. And I would urge you not to recommend the seller get a home inspection, because the seller is going to have to give that home inspection to the buyer. And the buyer, now getting that home inspection report, is probably not going to hire their own inspector. But what if there's a mistake in that home inspection report? Might the buyer now sue the seller for giving them a bad report? They could. So my recommendation is don't have the seller do an inspection. Now, if the seller wants to help pay for the buyer's inspection, that's great. Just let the buyer hire their own inspector, right? So if they hire a bad inspector, it's the buyer's fault, okay? And then paragraph 12 reminds the buyer is obligated to investigate the property. Paragraph 13, we do not share with the buyer how to take title, okay? That's something they should talk to with their attorney or maybe their accountant. Don't even tell the buyer how you hold title, because that could be viewed as a recommendation. And there are serious tax and legal consequences on how to take title. Okay. Moving on now to page 6. And here's the big paragraph, paragraph 14. More questions come up about paragraph 14 than any other paragraph in the contract. So what I'm going to do is I'm going to summarize this. When we get through it, I'm going to open it up for questions. And then I can go into as much detail about this paragraph as you want. The seller has 7 days from acceptance to deliver all reports, disclosures, and information the seller has on the property. Disclose all material facts. They have 7 days from acceptance. With that, since the seller presumably is going to be providing the TDS within those 7 days, unless they're exempt, and your AVID, your agent's visual inspection disclosure, or whatever disclosure you're giving for making your inspection, is referenced in the TDS, I think you have an obligation to provide your AVID within 7 days as well. So whether you're representing the buyer or the seller, my opinion is you need to give your AVID to the buyer within 7 days. Doesn't say so in the contract. You're not a party to the contract, but I think it's pretty tied together. All right. So I strongly recommend you give your AVID during those first 7 days. And then for 17 days following acceptance, so the 7 days and the 17 days run at the same time, the buyer has the ability to investigate, review reports, inspect, anything they want to do, right? And some buyers may want to come back twice or 3 times or even 4 times. Please tell your sellers they have to let the buyer in. We get sellers that say, no, they've already been to the property once. They don't get to come back a second time. That looks like the seller's trying to hide things, right? So I know it's a pain in the rear for sellers to keep having the buyer come over, but please let the buyer come over and make their investigations. Now, during these 17 days, the buyer may see things or discover things that they're not happy with. They can give a request for repairs or the RR form to the seller, asking seller to fix something. They do it in the first 17 days because they can back out for little or no reason during those first 17 days. So they have their negotiating room there. Once the buyers release their contingencies, now the buyer has to buy the property. Trying to get the seller to make a repair then is not going to be very effective. When the seller receives that request for repairs, they can either agree, not agree, or ignore it. They don't have to respond. But we'd like the seller to respond on the RRRR form. I think that's the response to the request for repairs, something. We call it the pirate form, right? RRRR. It's just the RRR form. Okay, so that is the form that the seller can respond as to whether or not they're going to make some or all of the repairs, or maybe they're going to offer a money credit to the buyer to buy the property, right? Sometimes we like to use money credits if it's something that's hard to verify it's been repaired, like a roof repair or something. Give some money back to the buyer and let them fix it, right? Anyway, we have this 17 days for the buyer to investigate the property, negotiate with the seller to try to get the seller to make some repairs. Anyway, now, if the seller makes a late disclosure, remember the seller's supposed to make their disclosures within 7 days. If they do one late, the buyer will then get an additional 5 days from the late disclosure. So if the seller makes a disclosure to the buyer on day 15, then the buyer has until day 20 because it has been extended, or the contingency period has been extended 5 additional days. That's under paragraph 14B3. Okay? The contingency continues until the buyer removes it in writing. Okay? Contingency continues until the buyer removes it in writing, and the sellers need to leave the utilities on during this contingency period so that the buyer can do an adequate job of inspecting. Okay? Now, under paragraph 14C, you can remove these contingencies with the offer, which means the buyer has no contingency period. Extremely dangerous and risky because the buyer has not had a chance to investigate the property, but the buyer's interest is to knock the house down and rebuild their McMansion. They might want to release the contingencies with their offer because they're going to tear the house down anyway, right? Okay, now, buyer's supposed to remove their contingencies within 17 days. What if they don't? The seller can give a notice to perform, okay, notice to buyer to perform, and they can give it 2 days early. So they can give it as early as the 15th day. Now, I always recommend you call the other agent up, ask them how the buyer is doing on their investigations, let them know the seller wants to move this along and has asked you to give over or give a notice to perform. All right. The problem if you just send that notice to perform over, a lot of agents get their nose bent out of joint. They think you're being rude, even though the buyer is supposed to remove their contingencies without being asked. But the seller's remedy is to first give that notice to perform. They can give it as early as the 15th day or as late thereafter as they want to. Once the seller cannot cancel unless they first give a notice to perform. Once they give that notice to perform, after 2 days, then the seller can cancel if they want to, but they don't have to. But they can't cancel unless they first give that 2-day notice to perform. Okay? Once the buyer has removed their contingencies, they're obligated to buy this property. If they don't remove their contingencies, the contingencies continue, meaning that the buyer can always cancel. All right? So the buyer is never going to be in breach of the contract until after they remove their contingencies and then fail to perform. If they don't remove their contingencies and then choose not to perform, they're not in breach, they can get their deposit back. They cannot be sued for the seller for breach because they're not in breach because they never removed their contingencies. Now, separate and apart from this removal of contingencies, let's say the buyer removed their contingencies. Everything is going well. And now we're coming up to close of escrow and nobody's heard anything from the buyer. Can't even get a hold of the buyer's agent. The seller says, well, the heck with this, I want to cancel. Not so fast. Before the seller cancels at close of escrow, they have to give a 3-day notice. And you'll see that in paragraph G. A DCE notice. The thinking is we want to give that buyer 3 additional days to try to get their act together at closing. This is separate and apart from the removal of contingencies. The buyer hasn't removed their contingencies. Seller can give a 2-day notice. After those 2 days, seller can cancel. But if the buyer does remove their contingencies, and now we're up to the close of escrow, and buyer isn't closing, seller cannot cancel unless they give at least a 3-day notice. Let's see if there's any questions in this paragraph. No, there's not. That's pretty amazing. H is sometimes misunderstood. It says that if escrow sends cancellation to one party and doesn't hear upon the request of the other party, escrow can cancel and give the deposit back. Escrow's not going to do that. The reason we have H, the second part of H, really stems from the old short sales. Remember, for those of you who are working real estate back in the short sale days, we would have an offer and acceptance subject to lender approval. The lender didn't approve, but escrow had the buyer's deposit. Seller has since moved back to Oklahoma, and nobody knows where the seller is. After escrow sending a letter to the seller at seller's last known address, 10 days following that point, if escrow wants to unilaterally refund the deposit to buyer, they can't. That's what's in the bottom of H. Also, if you have a situation where one of the parties is just being honoring, they're supposed to refund the deposit or they're supposed to forfeit the deposit under the liquidated damages clause, and they refuse to do so just because they're being nasty. They know they're supposed to, but they just won't. Then they can lose an additional $1,000 penalty for refusing to sign cancellation instructions and refund the deposit. So you'll find that in the bold at the bottom of paragraph H. Now we go to paragraph 7. I mentioned earlier, paragraph 15 is our final walkthrough to make sure the property is in the same condition as it was at acceptance, and any repairs that were done were properly done. Paragraph 16, any repairs done by the seller will provide paid invoices to the buyer, so the buyer knows that they were done and paid for. Paragraph 17, prorations of property taxes and other items. For you new agents, easiest way to explain a proration, if I'm selling you an apartment building and escrow closes on the 15th of the month, I've probably collected all the rents for the month, right? But since you're going to own it for the second half of the month, you're entitled to half of those rents. So what's going to happen is we are going to increase the price I am paying for the property, okay, to cover those rents that you're not going to get. Did I say that right? No, I'm sorry. Buyer is going to, you are the buyer, you are going to have your price reduced by a half a month's rent to compensate for the rents you're not going to get for the last half of the month. I always get that wrong. So property taxes, rents, insurance, things like that are often prorated. Paragraph 18 mentions that brokers are going to be compensated from a separate agreement, right? The listing agreement, the buyer representation agreement, however else. Remember, brokers are not a party to this contract. So brokers are not compensated from this contract, which brings up another point. If you ever write an offer on a for sale by owner, I know some agents will, in paragraph 6 of this contract, write in there, seller to pay a commission of blank %, and everybody initials it. Unenforceable. Unenforceable because the statute of frauds in California says that all commission agreements must have in 10-point bold type a notice that commissions are negotiable and not fixed by law. Secondly, since brokers aren't a party to this contract, they can't enforce it. So if you're writing an offer on a for sale by owner, you need to include the SP form. Okay, single party, that's the SP. SP, single party compensation agreement, creates an obligation of the seller to pay a commission without creating agency. And since you really don't want to create agency with the seller, since you're already representing the buyer, I would recommend you also include the SNA form, seller non-agency. It is a written agreement between you and the seller where you're not going to be their agent. But the SP form will still allow you to collect a commission from them, right? Paragraph 19, if an entity is buying or selling the property then you will be using that representative capacity, either for the seller or the buyer, okay? This contract only has a single signature line and a single name line. If you have an entity, you need 3 lines. You need to have the entity, the corporation or the trust. You need to have the name of the person, either the officer of the corporation or the trustee of the trust. And then you need the signer. So you need 3 lines, and we don't have enough lines. So if you have an entity, like a trust, a corporation, limited partnership, you need to include the representative capacity form. Paragraph 20 tells escrow what paragraphs that they need to be concerned with in this agreement. And that thing takes us to page 8. So let's see, we've got a question coming in. Let's see, could you please go over the liquidated damages clause? Yes, I will go over it, but we're not there yet. So I think that's what, paragraph 20 or 22. All right, it's actually 21, excuse me. So here we are, page 8, and our first paragraph here, remedies for buyer's breach of contract. Now, 21A is CAR's gobbledygook that essentially says there's no such thing as a non-refundable deposit, particularly in residential transactions. So you never, ever want to write non-refundable deposit, because the only thing worse than the unlicensed practice of law is the unlicensed practice of the wrong law. So if you're writing non-refundable deposit, not only are you drafting a contract, which constitutes the unlicensed practice of law, you're drafting a contract which is unenforceable, which means you're not following the law. I mean, it's horrible. So there's no such thing as a non-refundable deposit. What paragraph 21 does is it allows the seller to keep the deposit as liquidated damages, which is allowed, if the buyer breaches. Now, remember earlier, what did I say was a breach? The buyer fails to perform after releasing all contingencies. If the buyer hasn't released their contingencies, they don't have to perform under the contract. The buyer only has to perform under the contract after they release contingencies. So after the buyer releases the contingencies, and then the buyer doesn't perform, the seller can sue for breach of contract. Now, the problem with that is, what are the seller's damages? The seller will have to prove that they have actually lost something. And in contract law, we don't allow speculative damages. You see, in tort law, personal injury, if you want to sue somebody for colliding with you in your car, you sue them, right, for your injuries, including your pain and suffering. And you tell the jury how much you hurt and how painful it was. And the jury feels sorry for you and they gives you a lot of money. That's speculative, and that's allowed in tort law. That's not allowed in contract law. Contract law does not allow speculative damages. So the seller would have to have proven or have to prove that they would have sold it to somebody else. And of course, the seller doesn't have another buyer that they could have sold it to, because when they accepted this buyer's offer, they went into escrow and it effectively went off market, right? Effectively. So it's difficult for the seller to sue the buyer for damages under contract law. So what this clause does is it says that the seller may keep the buyer's deposit as liquidated damages. Now there is a cap. If the buyer is going to be living in the property or plans to live in the property, and the deposit was more than 3% of the purchase price, the seller cannot keep more than 3% of the purchase price. but most deposits do not exceed 3% of the purchase price, so it's going to be the deposit, all right? Now, that is liquidated damages. I do not see any questions, so I'm going to go drop down to mediation and arbitration. Now, mediation is mandatory. Arbitration, you have to agree. So, what mediation says is, prior to filing a lawsuit, you agree to sit down with the other party, with or without your attorney, and try to have the dispute mediated with a mediator. Anybody can be a mediator. It can be your parish priest. It can be your favorite bartender, your masseuse, doesn't matter. Now, it's always a good idea to have a mediator who is trained in mediation. And most mediators are attorneys, because it's helpful to have an attorney because they understand what a case is worth, and they're probably better to resolve it. A lot of your mediators are retired judges, but anybody can be a mediator because the mediator doesn't make a decision for the parties. It's up to the parties to decide whether they want to settle or not. And if they don't, then they can go sue each other or go into arbitration. Now, if the arbitration clause is initialed under 22B, then parties are giving up their right to sue in court, and instead they're going to have an arbitrator decide their case. The arbitrator needs to be either a retired judge or an attorney with at least 5 years of residential real estate law experience, all right? Unless the parties want a different arbitrator. The arbitrator will decide the case, and there is no appeal, okay? Now, there are some exclusions for mediation and arbitration. The most common is small claims. If you have a small claims matter, less than 10,000, you don't have attorneys, so the mediation clause, arbitration clause doesn't apply. If, however, you don't agree to mediate your case, and mediation is required because it's in excess of the small claims limit, but you choose not to mediate, you give up your right to attorney's fees if you win. We're going to see in the next section that there is a provision for attorney's fees if you win. You don't get your attorney's fees even if you win, if you don't choose or don't elect to go into mediation, right? All right, so now moving on to page 9. Almost done here. Paragraph 23, again, selection of service providers, escrow, title, home warranty, etc. Brokers do not guarantee their performance, and it is a choice between buyer and seller. Agents will, or excuse me, the listing agent will be reporting this to the MLS. If you are representing the buyer, 3 or 4 days after close of escrow, go into CRMLS, make sure that you are listed as the agent representing the buyer. Unfortunately, there are some agents out there who will report their listing sale, and they will put themselves on both sides, representing seller and buyer. Why? Well, if you ever go to work for a different broker, that broker will always ask you, how many deals did you do last year? They already know. They looked you up in the MLS, and it will show all of your deals. They just want to see if you're going to lie to them or not, right? You want to get credit for all of your deals. Not that you're not happy with your current broker, but you know, things happen, right? So you always want to make sure you get credit. If you're not listed as representing the buyer, call that agent up, be nice, just say, hey, went in to look at the closing of our transaction. I think you put yourself down on both sides. And they might say, oh, did I do that? I'm sorry, I got confused. No, they didn't. They're trying to get credit for your side, okay? Make sure they change it. Now, some of you might be working for a team. And traditionally, if you're working for a team, all transactions get recorded under the team leader. That's why you have these people out there that said, I sold a gazillion properties last year. Well, they didn't actually do it, their team did, but they got all the credit, because in the fine print it says, transactions are listed, those that were recorded under this agent's MLS number, right? Okay. If you're working for a team, you still want to get credit for your transactions. And this is how you can do it. At closing, make a copy of the closing statement, right, that escrow sends out, and save those. That way, if you ever are interviewing someplace else and the broker says, how many deals did you do? You could say, you know, I did 12 deals last year. I was working for a team. My deals all were recorded under, but here is a copy of all the closing statements on the transactions that I was involved in. Okay, so you get credit for those deals. Paragraph 25, I've already talked about attorney fees. Also, paragraph 26, the prohibition of assignment. We've just talked about that. Paragraph 27, we will comply with fair housing laws. Paragraph 28 and 29, this is the entire agreement. There are no other agreements other than this one. This contract cannot be changed and done so in writing and signed by all parties. Time is of the essence. Okay. Then we go into our definitions. Now, it's quite common in a contract to have terms defined, because what's a day? Is that a calendar day? Is it a biblical day in Genesis? Is it a business day? Well, days are calendar days. The only time we use business days is the length of time the buyer has to get the deposit to escrow. Tomorrow is always day one. And you'll notice this contract always talks about days after. It doesn't talk about days so much, it talks about days after. So whatever you do today, you give somebody something, you receive something, doesn't matter whether it's 8 o'clock in the morning or 5 o'clock in the afternoon, tomorrow is always day one, all right? Delivery needs to be personal. You need to hand them a copy. Can't use the mailbox rule here. It needs to be personally delivered and received by the other party, unless they give a designee. You see there in paragraphs 31, you can put yourself, the licensee working with the buyer, in that line so you can receive communications on behalf of your buyer, which I recommend because I don't want the other agent communicating with my buyer. So put your name there. Don't put your brokerage name there. Put your name there. And then, how long is this offer good for? And again, must be accepted by 5 p.m. on the third day, right? Or you can extend or shrink that, make it longer or shorter. The CAR felt, and I agree, 3 days should be sufficient time, right? The buyer then signs, go to the top of page 10, and this is where the seller can accept. Or, if they check the box in paragraph 32, they can counter. And you'll notice there's a place to put the date on the counter. Whenever we use a counter, we identify the date on that counter. Whenever we counter an offer or counter a counter, we always identify the date of that counter. Okay, that's where we know which contract we're dealing with. And then just kind of an aside here below the seller's signature lines. Remember, the seller will still sign if they're countering, because the counter offer accepts all terms of the offer with the following changes. So it's important for the seller to sign this even if they're countering. Now, the purpose of this little initial paragraph at the bottom here, this is so that we know that the communication of acceptance has been received. You see, it's not just offer and acceptance. It's offer, acceptance, and communication of the acceptance. So I make an offer on your listing. Your seller accepts. Do we have a deal? No. Okay. My buyer needs to know about it. So you need to communicate to me that your seller has accepted. So you should send back to me the signed contract. So you do that. But you don't know if I've received it yet, much less you don't know if my buyer's received it yet. So while it's not required, it would be really nice if either I or my buyer would initial this paragraph and then put the date that it was received. So I might put down September 24, 2020 at 11:45 a.m. And then I send this page back to you. Why is that important? Well, now you and your seller know we have a deal because the communication of acceptance has been completed. But more importantly, we all know that tomorrow, Friday, is day one. Day one for the 3 days, the 5 days, the 7 days, the 17 days, the 21 days, the 45 or 60 days for the escrow, whatever. We know that tomorrow is day one. Now, I said this wasn't required, and it's not. If you're in a deal and they don't use this, because they haven't been to one of my classes, this is what I would do. Follow up with an email. Don't use a text. It's hard to save texts. Follow up with an email and say, did your buyer get our acceptance? Or if you've got a counter offer, follow up with an email to the listing agent. Did your seller get our acceptance? Or, however. But did they get it? Okay. And they email back and they say yes. That happened yesterday. Then you email back and say, great, so today's day one. Or they say today, oh, great, tomorrow's day one. They say, yeah, what's the big deal? Today's day one, or tomorrow's going to be day one. The big deal is it's real easy for you and I to agree that today or tomorrow is day one, when today or tomorrow will be day one. It's not so easy for us to agree when day one was, when we're on day 15, 16, or 17, or 20, 21, and 22, right? We have these little disagreements on whether it's the 17th day or the 20th day, but you won't have that if you all agree when day one is, when you put the deal together. Finally, at the bottom of the page, presentation of offer. We know we have some concerns out there that agents don't present offers because they may have an offer themselves. Well, here they're stating they actually did present the offer, but I would go one step further. I would get my seller, if they're going to reject an offer, to go ahead and initial at the bottom. Again, not required, but it's a good thing to do. More importantly, if you've got a multiple offer situation, here's what I would do. Let's say 3 of you watching this video today brings offers on my listing. First thing I would do is I'm going to call each of you back. And I'm going to say, or if I can't reach you, I'm going to try to call you, but if not, I'm going to text you. And I'm going to say, hey, got your offer. Thank you. I wanted to let you know we're in a multiple offer situation. If you'd like to go back to your buyer and strengthen your offer, okay? I'm not planning on presenting offers until later today. That's a nice way of saying, hey, if you want to go back to your buyer and raise the price or get rid of some contingencies, now's your chance, right? So it's a nice, gentle way of saying that. Then I would also say, I'm going to be presenting offers tonight. If you would like to present your offer directly to my seller in person, we will be meeting with agents at 5 o'clock, at 5:45, and at 6:30. If one of those times works for you, I will be happy to have you come in and meet with the seller and myself and present your offer. This does a couple of things. First of all, there is no way in the world that agent will ever accuse you of trying to disfavor their offer, particularly if one of the other offers is coming from somebody in your office, because you've given them the opportunity to present their offer to you and your seller directly. Second, let's say their offer doesn't get accepted. They're not particularly happy, but they can't be unhappy at you because you did everything you could. They had a sucky offer, right? You did your job. You brought them in, right? Let's say they don't want to present their offer. You gave them the opportunity. So 3 months from now, when you're presenting an offer on one of their sellers, they'll deal fair with you as well. You see, most of the drama we get in real estate transactions are not because of the buyer or the seller. It's because of the agents, right? It's the agents that seem to create the drama when it's the agents that are supposed to decrease drama. So work well with that other agent, and you're going to find your real estate career is going to improve remarkably. Now, Laura, at this point, I don't have any questions in the chat room, which is kind of unusual because usually I've forgotten something. And we are right at about 10 minutes to 12. So did you see anything in the chat that I didn't answer, or?
No, you've answered them all.
Okay. Maybe we'll
Unless anyone has any last minute questions.
Don't hear or see any coming in. We might have some slow typists out there. I'm a very slow typist. You see my disclaimer here? You also have my contact information. Don't call me. Mount SAC has got all of their classes going online right now. So we have no face-to-face classes. So if you call me, you can leave a voicemail, but I'm not calling you back. I do have my email, and I'm happy to talk with all of you about education things. What I'd really like is, if you know anybody that wants to get a real estate license, send them to Mount SAC rather than one of those home study schools, because if you learned something here today, hopefully you did, you know that your friends will learn a lot more from me than studying some book or computer program, right? Because you got someone you can talk to. Even online, we have Zoom meetings like this that we can talk about. But I don't give legal advice. So if you need legal advice or tax advice, I'm going to have to refer you to somebody else. But if you just want to talk about a form, how a form is used, things of that nature, please email me. But go one step further. If you're going to email me, why don't you copy your broker or manager? Because sometimes I think it's helpful when I'm giving you a reply that your broker and manager sees it as well. Unlike some instructors out there, I don't buy or sell real estate, so there's no competition. Brokers and managers love me to talk to their agents for the most part, right? So we're all in this together. Where have you heard that before, right? And I look forward to talking about educational issues with all of you. And since it is education and I'm promoting the Mount SAC program, I don't charge, but I don't give legal advice, okay?
It looks like we have a question.
Can you email me a question later? Of course you can, okay? Again, just include your broker because I want to be as transparent as possible. Can you please clarify the timeline that buyers can get the deposit back? Anytime before the buyer releases all of their contingencies. Now, they're supposed to release their inspection contingency and their appraisal contingency on the 17th day, their loan contingency on the 21st day. I understand that's all going to get changed in the new contract to 17 days with the new contract next year. But they're supposed to do it in 17 days or 21 days. But if they don't, the contingency goes on forever. You see, the buyer can always get their deposit back unless, one, the buyer has released their contingency, and two, the buyer has initialed and the seller have initialed the liquidated damages clause. If the liquidated damages clause is not included, buyer always gets their deposit back. If the liquidated damages clause is not included, was not initialed by both parties, then the seller's remedy is to sue the buyer for damages. Are you going to go over a buyer agreement representation anytime soon? Yes, I have a feeling that Laura's going to email me after this class is over and ask when I'm going to do a class, because she always does that to me. Let's see, can you explain again on the importance of the AD before showing properties to the buyer? What power does the AD have? The AD fulfills your legal requirement to disclose agency before you have a client. So the law says you must disclose. Now, with our buyer, since I know most of you are not using that buyer agreement, that buyer representation agreement, most of you create agency with your buyer verbally or with an implied agreement. At some point, they think you're their agent and you think they're your client, right? Or you might say, hey, can I represent you? And they say, yes, you can. That's an agreement. Before you do that, you're supposed to have them sign the AD form. If you don't, then your agreement is not valid, which is why I say, get the AD form signed before you start showing the buyer. Here's your script. Mr. and Mrs. Buyer, so excited having an opportunity to take you out and show you some properties. Before we get going, the law requires I explain to you the difference between single and dual agency. In single agency, our company will only represent you. In dual agency, that means you want to write an offer on a listing that somebody else in our company has. So this is the form that explains the difference. I'm required by law to have you sign that. Oh, by the way, since it is possible that you might want to write an offer on one of our listings, that would mean going into dual agency. This second form, called the PRBS, discloses that that might happen and you're good with that. Would you mind signing that as well? As soon as you sign those, I'm going to give you copies and we can go out and look at properties. That's all you have to do, all right? Nice, simple, just do it matter of fact. Don't make a federal case out of it, right? Just get it done, then you don't have to worry about it. If the appraisal price is lower than the purchase price, what can you do? Well, you can ask the seller to reduce their price. Basically, it's not a request for repairs, it's a modification of the contract where the seller is going to reduce their price to the appraisal price. And the argument that you make is, seller, you got an appraisal at $750. I know we went into escrow at $760, but appraisers are saying your property is $750. Yeah, we can cancel this. You can go back out on the MLS, but you know what's probably going to happen? You're going to get another offer and another appraisal at $750 because that's where the comparable sales are. So you kind of have to negotiate there. Or buyer can walk because it's a contingency. You mentioned the rejection of the offer in the last page is not required. Would it be, let's see, would be sufficient then as a courtesy to let the buyer's agents know by phone, email, or text that the buyers, yes, it is a nice courtesy. But the reason I like the seller to initial that last line, okay, is now the other agent has proof from the seller that they rejected the offer. That agent cannot think that you just didn't present the offer. And some of you do know of stories, and maybe it happened to you, where you suspect, or maybe you know, that the agent never actually presented an offer because they had an offer from their own buyer that they were trying to get accepted. Totally a breach of fiduciary duty, but unfortunately we do have some bad agents out there. If the buyer removed the contingency already, but can't close on time because the issue with the loan, can the seller charge the buyer a late fee? Yes. Good question. This is how I would do it, because you don't want to do a non-refundable deposit. So let's say the buyer needs 5 more days. Have escrow prepare an extension of escrow and contract, because you're extending the contract and you're also extending escrow, in exchange for a 5-day or a 1 week or whatever extension of contract and escrow or closing date. Buyer agrees to pay seller X amount of dollars. So let's say $500. You can put any amount you agree upon. So what's going to happen is the buyer now gives the seller $500. They can either do it through escrow or however they want to do it. I recommend do it through escrow. But the buyer gives the seller $500. Seller now has $500, and the escrow closing date has been extended for 5 days or a week or whatever. Now, we come to the end, buyer still can't close. Buyer can't get their money back. Not because it was a non-refundable deposit, but because it was consideration for an extension of time. You see, under the law, the only way to rescind that is to put the parties back in their original position. So if you want to give the $500 back to the buyer would have to give the seller their week back. And since we don't have time travel, you can't do that. So that's how you can have that money released to the seller without it being a non-refundable deposit. You make it consideration for the extension of the closing date. Any other questions? Not seeing anything. Okay. Laura, do you have anything?
I do not. I'm good. Thank you for today.
Okay, you're very welcome. Thanks to all of you, and I look forward to seeing you or hearing from you in future classes.
Okay,
Bye-bye.
bye, Ed. Stay safe out there.
Okay, will do. Thank you. Bye-bye.
Bye.